Michael Ankumanimfa, the plaintiff, filed the application after obtaining a judgment at the High Court in Cape Coast, which prohibited Gyakye Quayson from assuming the role of a Member of Parliament. The plaintiff argued that Gyakye Quayson was not qualified to contest as an MP since he had not properly renounced his Canadian citizenship at the time of filing his nomination as required by Article 94, Clause 2A of the 1992 Constitution. The plaintiff contended that the proof of renunciation was received by Gyakye Quayson after the nomination had already been filed, thus not meeting the constitutional provision for dual citizens to run for Parliament. The High Court in Cape Coast upheld the plaintiff's case, resulting in the defendant being prevented from acting as a Member of Parliament for Asen North. James Gyakye Quayson then appealed the decision at the Court of Appeal. It was during the appeal process that the plaintiff filed a current application at the Supreme Court, invoking its original jurisdiction to interpret Article 94, Clause 2A of the 1992 Constitution. The plaintiff requested the Supreme Court to declare that James Gyakye Quayson was not qualified to contest as an MP, and that the Electoral Commission's decision to allow him to run, his election, and subsequent swearing-in were all unconstitutional and null and void. The Apex Court, chaired by Justice Jones Doche, granted the relief sought by the plaintiff. Frank Davis, the lead lawyer for the plaintiff, expressed appreciation for the judgment of the court.
We have to protect the sanctity of the Constitution, and we are gratified that the law lords, all the 7 of them, have agreed unanimously with the position we have held all along, that at all times material, James Gyakye Quayson was not qualified under the dictates of the Constitution of the Republic to have contested as a Member of Parliament for the Asen North constituency.
The 7-member panel subsequently instructed Parliament to remove the MP's name from its record. The New Patriotic Party, which has shown interest in the matter, is hopeful that the by-election will be held in Asen North soon.
As far back as July 2021, the High Court had told the Electoral Commission to conduct elections in Asen North. The party has always been ready that any time soon the EC comes out, we are ready to go.
Meanwhile, James Gyakye Quayson has expressed disappointment with the judgment. The defendant in the case argues that the facts regarding the renunciation of his Canadian citizenship are public knowledge, and in his view, the facts indicate he had indeed renounced his citizenship. In a statement responding to the judgment, James Gyakye Quayson noted that he lost all rights as a Canadian citizen when he filed for the renunciation in 2019. James Gyakye Quayson, who has decided not to pursue the matter further, has, however, assured his commitment to the development of Asen North. The minority leadership in Parliament views the Supreme Court's decision as a blow to Ghana's democracy. In a statement signed by Minority Leader Dr. Citi, the minority indicated that they will announce their next course of action after carefully reviewing the court's reasons for the decision.